This is a topic which has always interested me. Each one of us in this room, everyone sitting in here, is a lawyer. We engage in the study and practice of how and when rules apply. So why is it that we are taught a huge amount in our CPD and in our training about what we can and cannot do, the limits of our own ethical world, but we're almost never taught, and we rarely discuss, the limits of what a judge can do in their conduct of a case? I'll start with an anecdote which explains where some of my interest in this topic comes from. So I was an embryonic barrister. It was a wills case, and I was there to take a note. We were on to a winner. The other side were running testamentary capacity, and the evidence of their key witness just didn't come up to proof, nowhere near. The barrister I was following told the trial judge and his opponent that he didn't require the attendance of that witness. We had no questions for them whatsoever. And the judge, who was clearly smelling a rat, observed that they might have some questions for the witness and that they should probably attend in any event. And this nameless and brave, if not foolhardy, counsel paused and considered that proposition, and then quietly suggested to the judge that if they wished to call evidence as opposed to clarify it, that we might be entitled to see a witness statement from them. And that stayed with me for fairly obvious reasons and is part of the inspiration for this talk today. Just like Tony Blair and New Labour in 1997, I have 5 pledges, or 4 actually, and our aims are these. We're going to look at a topic which is rarely discussed and poorly understood. I'm going to try and draw out some broad principles from the case law. I'm going to give some guidance for what you might do if you are faced with a tribunal that you feel is overstepping, and hopefully I will teach you a new word. That last one certainly feels like an attainable objective. So those are our aims. How are we going to achieve them? Well, first of all, I'm going to look at the doctrine of judicial notice and how it can be used and abused. And there will be some mild audience participation, so please prepare yourselves. Then I'm going to look at the broader topic of entering into the arena. What it is, how to recognise it, and once you know how to recognise it, I'm going to finally look at what should you do. Judicial notice. The starting point, and I think probably everyone would agree with this, the starting point in any case is that a judge should not decide a case based on their own knowledge. If you have material to impart during the course of a trial, material facts, then you're not a judge, you're a witness. There are, however, 2 related exceptions to that. The first is a line of cases which basically says certain specialist local knowledge is admissible, where it's done properly and within reasonable limits. So, for example, in the context of Newcastle, there's frequently bad traffic on the central motorway at 5 p.m. The second exception to the rule, the one that we're focusing on today, is the doctrine of judicial notice. So, fundamentally, well, I'm not going to ask anyone to attempt a definition, but fundamentally it is a time-saving device. At a trial, you are not required to call evidence of things that are either formally admitted by the other side or are judicially noticed. And judicial notice comes in 2 strands. The first is certain things that are prescribed by statute. So, for example, the contents of company's house, things like that. A judge can take account of those. The second, which we are concerned with today, is notorious facts. So, for a bit of fun, I thought we might look at some notorious and non-notorious facts. So, there have been rulings on each one of these in decided authorities, and see if we think they are notorious or not, how well they stand up. And the relevant test is, for a judge to judicially notice something, it must be so notorious as not to be the subject of dispute amongst reasonable men and presumably reasonable women. The first notorious fact that I proffer to you is this: the streets of London are crowded and dangerous. You raise your hand if you think that's notorious? Think it's so uncontroversial that you don't have to prove that at trial, at least according to the authorities? Okay, no takers. I'm going to assume everyone thinks it isn't notorious. That actually is a notorious fact. So unless the court chose to depart from the earlier authority, technically speaking, you wouldn't have to prove that at trial. The life of a criminal is not a happy one. What do we think? Do you think that is a notorious fact? If you think you don't have to prove that at trial, raise your hand. Okay, well, you all glamorize the life of criminals clearly, because that is in fact a notorious fact. You do not have to prove that at trial, apparently. The cost of living is higher in the Bahamas than in England. Anyone in the room think that is a notorious fact? Raise your hand now. Yeah, no, that's not. That was found not to be. You do have to prove that. Boys are naturally reckless and mischievous. Do you think you have to prove evidence to call that? Call evidence to prove that? Raise your hand if you think it's notorious and you don't. Yeah, a few. Yeah, you're right. That is a notorious fact. So if your case turns on the mischievousness of boys, or on the recklessness of young boys, you do not have to call evidence theoretically on that point. Soviet Russia was a trade monopoly. I can only imagine the circumstances in which this had to be decided, but this is not a notorious fact. Banks are not open on Saturday afternoons in Mauritius, also not a notorious fact. You do have to prove that. And then finally, and this was decided in a very recent case, the quote is, "Persons who operate a cash business, such as taxi drivers, do not always declare their full income to the revenue." Right. Do you have to prove that taxi drivers are dodgy? So, if you think that you don't have to prove that, and it speaks for itself, raise your hand now. Yeah, you're right. So the higher courts have found that that is something that can be judicially noticed, that taxi drivers and other cash-based industries, they will dodge their taxes. So look, some of these obviously might stand up better today than others, but fundamentally the takeaway is that if a judge, either in a judgment or during the course of a hearing, wishes to invoke judicial notice, and it's not a matter that's reserved in statute, it has to be notorious. It has to be so notorious that reasonable people wouldn't disagree about it. Having dealt with our warm-up topic, notorious facts, we're going to turn now to judges entering the arena. So I'm going to start at a level of generality before looking in a bit more detail about what a judge is or isn't allowed to do. But in order to do that, in order to draw the line and be able to say this far and no further, it's important that we're conceptually clear on what the role of a judge is. And to my mind, it was best described, and the authorities bear this out, it's often cited with approval. So the role of a judge is to hear and determine the evidence, the issues raised by the parties. It is not to conduct an investigation or examination on behalf of society at large. And incidentally, the appeal I've taken this quote within a quote from is an appeal from the late Judge Contran, who was a recorder who sat in the south of England. Now, Judge Contran appears to have been an extraordinarily difficult tribunal because on 4 occasions the Court of Appeal overturned his decisions on the basis that he had run the trial in an unpleasant and aggressive way. So if you are looking for authorities in this area, those are an excellent starting point, and you can obviously find them just by searching his name. Back to the definition. Judges are there to look at the cases as brought by the parties. They're not inquisitors on the behalf of the general public. Does that mean they're simply an umpire? It doesn't. A judge has a wide degree of latitude. Their object is to find the truth and do justice according to the law. The line comes, and this is what we're going to look at now, as the title of this section suggests, at the point at which a judge descends into the arena. So they go beyond striving for truth and justice, and they descend into the arena and they get their hands dirty. Because at that point, as the quite poetic quote from Lord Green set out on this slide reads, the judge will have their eyes clouded by the dust of conflict. I promised you a new word. It was a new one for me. Here it is. Arrogate. To claim or take something without justification. And what a judge must not do is to arrogate to themselves an inquisitorial role, because as we've discussed, that is at odds with the adversarial system. Incidentally, I suspect that this is a good phrase for your notebooks, or for drafting grounds of appeal if it ever does arise, that the judge arrogated to themselves an inquisitorial role. So that's the general level. That's what we're looking for. Diving now into the details, some particular features that arise from the cases. Seifin and Malkowicz is a 2019 case, and it was first heard before Mr. Justice J, he of Leveson inquiry fame, and concerned an allegedly defamatory material which had been published in a Polish language newspaper. It touches on various things, the questions of what sort of questions a judge can ask, the frequency of interventions, and what we have here is, or what you have on your handout at 7.1, page 11, is a key quote from the Court of Appeal. Now, incidentally, this also went to the Supreme Court, who largely upheld the Court of Appeal. So most of the quotes, or if not all of them, I've put in here are from the Court of Appeal, but the Supreme Court judgment is worth looking at. And it's one that I will read. On numerous occasions, the judge appears not only to have descended into the arena, cast off the mantle of impartiality and taken up the cudgels of cross-examination, but also to have used language which was threatening, overbearing, and frankly bullying. So what went so wrong in this case that this very learned judge came in for criticism for both the Court of Appeal and the Supreme Court? Clearly you are not permitted, or a judge is not permitted, to use threatening or abusive language or to bully witnesses. And on the question of the quality of questions a judge can ask, this really, as far as I can see, is the leading answer. It's perfectly proper, indeed it's a duty for a judge to intervene in the course of witness evidence, to ask questions which clarify ambiguities in the previously given answers, or identify the nature of the defence if it's unclear. So the key words here are clarify and unclear, and that's why in the anecdote I told at the start, I think the advocate was right to stand up to the judge. The evidence in that case was clear, it was unequivocal. It didn't contain any real ambiguity which required clarification. So on the quality question, we have our answer, only questions which are there to clarify. But obviously a judge can unwittingly derail a trial in other ways. For example, if they ask questions at inconvenient times. This question was dealt with in the case of Keane and Sargan, again set out in your handout, which was an appeal against ICC Judge Jones. Now, in the Court of Appeal, it's strictly obiter on these points, but it does provide a very useful guide. In Keane, counsel had asked the classic question when faced with some new evidence which emerged for the first time in the witness box. Well, where's that in your witness statement? And the judge intervened, and you'll see the transcript in your handout, but essentially, to paraphrase, took the witness to the relevant part of their statement, allowed them to read it through, and basically gave them some pointers. And as per the court in Keane and Sargan, that was something that the judge should not do. And they referred to this quote from Lord Justice Denning, as he was then, which comes up time and time again. The gist of cross-examination lies in the unbroken sequence of question and answer, and it loses much of its effectiveness if the witness is given time to think about awkward questions. So the upshot of this is that repeated interruptions, even in key passages of cross-examination, can give a freestanding ground of appeal, even if they're perfectly legitimate questions to be asked. Generally, the Court of Appeal guidance is, unless it is a very long trial, judicial intervention should really be kept to the end of the cross-examination so it doesn't interrupt the flow. So I recently did a case for a solicitor in this room, actually. And it was a trusts trial, and I was partway through cross-examining a defendant, matter being heard by a part-time judge who is not in the room, and I won't name. And I was cross-examining. Naturally, it was going very well. The witness was encountering some real difficulties. He was struggling. We stopped for a break in the evidence. I think there was a toilet break or something, while the witness was still in the stand halfway through the evidence. And at this point, the deputy judge informed my opponent, incidentally, Mr. or Mrs. X, I don't believe a word your client is saying. Well, we finished the cross-examination of the case and settled on pretty advantageous terms shortly thereafter, as you might expect. But it struck me as wrong at the time. It felt fundamentally unjust, even though we were on the benefiting side on that day. And the reason for that is, it turns out it is wrong. A judge, of course, may come to a provisional view about the truthfulness of a witness while cross-examination is underway. But the role of the judge is not to come to a conclusion at that stage, let alone to voice one. And the reasons the Court of Appeal say that a judge should not do this, and it is unfair, is A, it shuts down valid lines of cross-examination. B, it can give a witness a false sense of comfort or discomfort, which might end up being misplaced when the final judgment comes out as to how their evidence is going. And it makes the task of the cross-examining lawyer much harder. So, at this point, just to recap, a judge's questions should only be those of clarification, where it is unclear. A judge should not ask too many questions during cross-examination to interrupt the flow, and ideally leave them to the end. And unsurprisingly, a judge should also not give an ongoing view or commentary on how a witness is doing during their evidence. So all of this really poses the question, what if the judge does intervene, but the case they derail was absolutely always likely to lose? And the answer is, it doesn't matter. So the takeaway here is you've either had a fair trial or you haven't. If it wasn't fair because there was excessive or inappropriate intervention, then an appeal should be allowed, irrespective of the merits of the underlying case. And again, quite aside from that authority, that simply must be right. To borrow a phrase from the recusal jurisdiction, justice must be done and seen to be done. So, drawing things to a close. What should you do? What do the higher courts say you should do if you're faced with an over-interventionist judge? The first point is to seek a ruling if appropriate. If an issue keeps coming up, a disclosure point, a point of admissibility, and it's disrupting the trial, the safest course is to seek a short adjournment and ask for a preliminary ruling on the issue. That way, as the case on the screen indicates, you'll bank any potential appeal point, and hopefully the trial can continue in a more regular way. And the higher courts will expect solicitors, barristers, advocates to do this. And the second point, again, fairly obvious, not massively comforting, is that you have to put your case, do your job. This proposition was confirmed by the Court of Appeal, if it needed to be, in a recent case called Re B, which was an appeal from a recorder sitting in Teesside, in which Nick Stoner, KC of our chambers, who didn't appear below incidentally, successfully overturned the decision of that recorder. And it was a case in which one party, faced with a hostile judge, had just abandoned any attempt to put their case, and then subsequently appealed. Well, the Court of Appeal allowed the appeal in that case, but did specifically comment on the failure of the advocates to put their case, essentially saying, sometimes it's difficult, sometimes it's hard, but your job is to put your case, and the fact that a judge is intervening too much does not relieve you of that duty, and you will be criticised if you don't do it. So, to reiterate, this has been necessarily, because frankly it's a book or two books, if properly explored, at a general level. But I hope it has piqued your interest, and I hope that you will return to some of these authorities in the handout. If you're faced with a difficult judge, seek a ruling on any contentious points that keep coming. Be sure to put your case, even if the judge is trying to shout you down, and consider whether the judge has entered the arena, and if so, you may want to consider an appeal on the grounds of a procedural irregularity for a lack of a fair trial. Incidentally, I should say, this is not something we have to contend with very much on the North Eastern Circuit, I'm delighted to say. But that's all I have to say today. Thank you so much for listening.